Hey class. Uh, Today I'm going to briefly talk to you about U.S. Constitution and its structure and ratification. Uh, to begin with, the structure of the Constitution it was divided into 7 articles. As you can see, uh, each article pertained to a particular uh, set of um, requirements for the new government. The first 3 articles concern themselves with the structures of the 3 branches of government: legislative, executive, and judicial branches. The 4th article concerned itself with the relations between the states and the national government. 5th article concerned itself with amending the Constitution. Of course, they had to provide a means by which the um, states or the legislature could initiate a process to change the Constitution. 6th article laid out the very important idea of that national law would be supreme over state laws. It's an issue of conflict of laws. How do you resolve when you have a federal system where you have multiple levels of government coexisting? It also had to do with prohibition of religious oaths, that kind of thing. And finally, the 7th article laid out the grounds to ratify the Constitution, or in other words, to approve it. So one of the key means by which the Constitution was ratified was through the newspapers. There were states that were quite reluctant to sign on to this radical idea, moving away from the Articles of Confederation, which, as you already know, had laid out a system of 13 sovereign, independent states that had were more partners and goodly fellowship as opposed to an actual central government that had some power, to a system where the central government would have considerable power. New York, for example, was one of the battleground states as to whether or not ratification would occur. And the Federalist Papers were written by advocates for the adoption of a constitution with a strong national or federal government and a federal system. So the authors of the Federalist Papers, there were originally, John Jay was originally going to be the primary author. He wrote 5 and then got sick. He caught pneumonia. And so the mantle fell to James Madison and Alexander Hamilton to write the lion's share of the Federalist Papers, which were essays. They wrote essays and published them in the newspapers under a pseudonym, a fake name, Publius. That was Hamilton's pseudonym, his pen name, so to speak. Now, the Federalist Papers are really important because they laid out, first off, an advocacy for why the system would be a better one to have than the Articles of Confederation. But also, they give us today an idea of how the Constitution should be interpreted. These were, after all, in a sense, advisory committee notes from the people that actually wrote the Constitution to say, how is this thing supposed to work in practice? What was the original intent of the founders? And these convinced a lot of people to support the Constitution, despite some very legitimate concerns. There were anti-federalists, the opposition to adoption of the U.S. Constitution. These were called anti-federalists. They also published essays against the idea of adopting this Constitution, and there are anti-federalist papers as well. They're collected essays, which are really an interesting read if you ever are so inclined. One of the big concerns that states had against adopting this Constitution was the lack of protection of civil liberties, of individual liberties contained in the Constitution itself. There were really only three protections spelled out in the body of the Constitution. They were the prohibition of ex post facto laws, the prohibition of bills of attainder, and then a guarantee of habeas corpus. So an ex post facto law is a law that punishes actions that, when the action was committed, weren't against the law. So, for example, if on Monday you were to write a story that criticized the mayor for the local paper, and then on Wednesday, the national government passed a law making it an offense to criticize public officials in newspapers. Let's leave aside the constitutionality and all that kind of thing. And then someone sought to punish you for that action that you took on Monday under the law that was passed on Wednesday. That wouldn't really be a valid law. Again, independent of the First Amendment problems and whatnot. Bills of attainder were a prohibition against laws that single out a single person or a group for punishment without a judicial trial. So the legislature was prohibited from writing a bill to pertain only to one person, and that would then assess a penalty against that person. The whole idea of the rule of law, this protection of the idea that we need to make sure that a judicial process is followed, due process is followed, outside of the hands of the elected officials taking judicial matters into their own hands. Finally, a guarantee of habeas corpus, which protects against illegal detention. Essentially, habeas corpus is a long-standing principle in English law that we in America also adopted, which basically says, a person has to be told why they're being held by the official, by the government, within a reasonable amount of time. And this is still a litigated matter today. These are important principles, and they're the only three protections directly written into the Constitution. And a number of states were concerned that there wasn't a list of the rights of the citizens against their government, to protect the citizens from their government. Other founders argued, hey, we don't really need that. The government's not going to take advantage of people. But the best argument against ratification was that the Federalists didn't have some sort of list of the rights of the people. And several states demanded a Bill of Rights as a condition of ratification of this document, of this Constitution. Massachusetts, New Hampshire, Virginia, New York, North Carolina, these are big states, big, powerful states. And so the Constitution was adopted, and one of the first actions of the Congress was, in 1789, was to draft a Bill of Rights. So these would become amendments to the Constitution, and they're the first 10 amendments, first 10 changes to the Constitution. James Madison, a Federalist, you might recall, we just mentioned his name a little earlier, about writing as an author, one of the authors of the Federalist Papers, was charged with writing the Bill of Rights. And he actually came up with 12 amendments, 11 of which have been ratified. The first 10 amendments, of course, ratified by 1791. The 27th Amendment, which is the last amendment to have been ratified as of this recording, limited congressional pay raises. And that was ratified in 1992. The 12th, the one that got away, had to do with the apportionment of the Congress in 1790. So that one obviously isn't really relevant in the 2000s. So 11 of these amendments have ultimately been adopted. And these protections, it's really important to remember that the Bill of Rights, these first 10 amendments to the Constitution, were intended to protect the people from their own government. The concern was that the central government was given so much power that it might abuse it in relation to the people. And so if you'll note, when we go through the Bill of Rights, you'll note that they are written in such a way as to limit the power of government, to limit the Congress. Congress shall not do this. Congress shall not do that. And thus protecting the rights of the individuals. Okay, we'll talk further in class. Please bring your questions. Bye-bye.